high courts on certain topics. What do you think is the binding value of those kinds of orders before the court?
Undoubtedly, an interim order is not a binding precedent. But can you cite interim orders? And certainly they are not persuasive. Second, courts have said, Supreme Court has said actually, Vishnu Traders is the, I think, leading case on that, to say that consistency in interim orders is desirable and courts should not. So there are tax cases and there are a lot of cases at the land acquisition where Supreme Court says that consistency must be maintained. It's not as if I like your face, I will give you an interim order, I don't like your face, then I will not give you an interim order. It can't be like that. Arbitrariness in granting or refusal of interim orders can also be challenged. So interim orders on their own may not be binding, they are of persuasive value, but if interim orders on similar facts have been granted, then you have a right to rely on them and consistency must be followed. Short answer, but this is what I think.
Rohit sir, if you would like to add on to this difference between the law of precedent and judicial discipline.
Law of precedent and judicial discipline are actually synonymous to each other. Discipline is to be followed, and discipline is very necessary, whether it is an administrative discipline or judicial discipline. And the final words should be there. If there are no final words in the judicial system and judicial discipline, then it will be very difficult to follow the system. And in India, we have adopted the judicial hierarchy. And there is a Supreme Court. And even in the Government of India Act 1935, when we did not get the independence, then also there was a system of judicial precedents. And the Privy Council and those courts were, decisions were binding. So I think this is the very important, and that's why I told you in the initial remarks, if we are going to discuss the exceptions largely, and even Ashish Agrawal case, 148 cases, and if we discuss those cases, it will be disturbing the core of the judicial discipline, and discipline must be followed, and hierarchy needs to be checked in each and every stage, but subject to the per inquiry. So that in short, if there is any specific query, I will.
So Rohit sir, if we may continue with that. So sir, you were saying that precedents can be quoted before different authorities. Now when it comes to the executive branch, you cannot per se give them precedents. For example, somebody is being arrested under section 69. So can they go and say, no, first you follow Nesh Kumar only, then you can take me away? No, they will not. They will not ultimately listen to you. So what are your thoughts on that?
You know, it is very important when we are appearing before the lower authorities for adjudicating authorities. And practically, if you are going with the lower authorities only on the basis of precedents, I think that will not be the correct approach. First of all, the legal grounds can be taken at any stage of the proceedings, but the factual grounds are very important. And that is the right time to give all the relevant facts, the relied upon documents, evidences, and whatever you want to say about the merits of the case, that you should say there. Like I give you one example. If there are a lot of matters are going on in input tax credit, and if you see the GST implementation, the ITC issues were already there under the SANVAD. We have the legacy of judgments there from the Central Excise Service Tax Statute, but whether they will be applicable per se on the GST, it is a question of discussion. I will come to that issue also later if comes. But the point is that if I say it is my fundamental right, it is my vested right to claim the ITC and I have claimed it, then you are saying with the lower authorities, without going in the merits, without going in the evidences, then I think you may lose in the battle. But if you are saying that I have claimed the input tax credit based on the valid documents, based on the provisions of section 16(2), I have fulfilled all the conditions. I have the tax invoice in my possession. I have received the goods and services, and the evidence regarding maybe the goods movement of documents, guilty or the e-way bill, and I have claimed it in the return which I have filed, and all the condition has been fulfilled. So that means I think that is the approach which we should take at the initial level of the adjudication. And so far as indirect taxes, because I mainly belong to indirect taxes, and I think sir also doing indirect taxes mainly. But in direct tax also, the fundamental applies same, so far as the taxation law is there. But if you say judicial discipline regarding the applicability of precedent, direct and indirect tax may be same. But if you go for the interpretation of the statute, if you go for the definition interpretation, that may not be the correct. Whatever is the genesis of income tax may not be the genesis of GST, because it is a when the burden has been shifted on the buyer, the genesis may not be the same. So this is the approach we should have at the initial adjudication phase, right?
Tarun sir, if you would like to add on to it.
See, starting from your question, I am being arrested. I should not go and cite a judgment there. Well, if you are being arrested, you will certainly not cite a judgment there, because he will not listen, he or she will not listen, who is arrested. But the importance of a binding precedent doesn't lie in whether that man or woman doesn't listen to you. Will a binding judgment give you the right to go to court and make him listen? That's the issue. The importance of binding precedents cannot be taken away just because you are in a position of coercion with the department. Binding precedents are important even at that stage. If the person is acting contrary to law, late night, then it offers you the right to go to the court to make him listen. So I wouldn't say that it has no importance at all. It does have an importance. Taking from what Rohit mentioned about how we cite cases when we are before departmental authorities. See, I've done a lot of original work as well, and now I do largely courts. One thing which I find invariably, and I think it's important to talk about this issue in a gathering where we are all professionals. Cases, what I find normally is cases are just cited saying I'm relying on 20 cases, and then you keep multiplying those cases. You haven't laid a factual foundation for a particular precedent to apply, because the law in the country is on law precedents that a judgment has to be read in the context of the facts of that. It doesn't apply generally. Even if you can call out the issue, it doesn't apply generally. You have necessarily. The way to cite a judgment in your reply, or even while you are arguing it, is to first lay the factual foundation as to how a particular legal principle applies to you. Second part, cite the law, state the ratio that you want to rely upon. And third, state why that ratio applies in your facts. These are three parts to citing precedents. Factual foundation, what the judgment says, and how that judgment applies to your facts. If you are able to do that, and even then the judgment is not followed, when you stand up in court challenging that order which does not follow the judgment, I think you have a fair chance that the court will say that yes, this is how you have explained as to how the judgment applies, and despite that it's not being followed, hopefully you will get some success.
To add on this issue, I quote Bajaj Auto Finance CIT versus CIT 2018, what the Honorable Bombay High Court has held. The above submission that the decision of court or tribunal interpreting the provisions is to be ignored by the assessing officer, if accepted, will ring the death knell of the rule of law in the country. The assessing officer is bound by the views of the court. The above submission ignores the hierarchical system of jurisprudence in our country. Another case, Bank of Baroda versus H.C. Srivastava, That is also Bombay High Court, and I think on this law of precedence, Bombay High Court has taken the edge, and that is on the direct tax side. But so far as the law of interpretation is concerned, that is equally applicable for indirect taxes also. And in Bank of Baroda case, it has been held that the judgment delivered by the income tax tribunal was very much binding on the assessing officer. So, while discharging their quasi-judicial duties, they cannot ignore the precedents. And like Tarun Gulati sir has also mentioned, if any precedent has been grossly ignored, you can go straight away directly in the writ jurisdiction 226 rather than going for the alternate mechanism. And you can say this particular order has been passed ignoring the binding precedent, and the writ may be accepted on this ground itself.
Star judgment is Union of India versus Panama. That is the Supreme Court judgment.
What is about immunity is granted to the officials by the Act itself?
You know, that is something I will also add on. There may be a case.
GST law which provides immunity to the GST officers versus contempt. Please discuss
That is not there. That is not
The
there.
immunity from adverse action personally is granted under the law. But when you are before a court, in exercise of powers under 226 and 227, at least in 15 cases that I have argued, the courts have hauled up the officers and imposed personal costs. It's another matter that in situations where you don't want, personally as a practitioner, one doesn't want that the officer should be personally prejudiced. In fact, I have appeared in the Supreme Court case and it became quite unnecessary. And I must tell you this, that I was arguing a matter in the Allahabad High Court where after we filed the writ, the officer became aware that he is going to get slapped. He withdrew the order that I had challenged. So I got up on the next day and told the judge that the order has been withdrawn. The judge says, Mr. Gulati, that means you want to say that the writ should be dismissed as infructuous because you've got your writ. I said, my lord, as far as I am concerned, that is the correct position. He says, but no, now it's between us and this officer.
Immunity is available after paying 20%.
Immunity apart, the court went on to describe the manner in which the officer had treated the SSE, the manner in which it failed to follow an earlier judgment in the same SSE's case, made remarks about his conduct, saying that he should not be given any adjudication powers henceforth, and imposed personal costs to be recovered from his salary. Now, just hear me out. This is what happened in the High Court. The state accepted the judgment. It was against state of UP. The state accepted the judgment. So there is immunity under the Act. High Court has done this. This man files an appeal to the Supreme Court in personal capacity. Now, Supreme Court entertains that appeal because it's the career of a person. So High Court has said that this man should never be given adjudication power, it's pretty much end of the career of that person. Now, I was appearing as a respondent. Supreme Court judge asked me, what is your stand? I succeeded in the High Court. The client has got the relief. Now this man is on the dock. What does a professional do in such a circumstance? I told the court fairly, and it's a reported judgment authored by Justice Maheshwari recently, Dinesh Maheshwari. I said that as far as I am concerned, I did not ask for this. The court did feel that the officer was unreasonable. As far as I am concerned, costs have been ordered and I have been given costs also by the state. I am willing to deposit it back. The court appreciated that and deleted the remarks by a detailed judgment to say that this should not ordinarily be done. We as professionals come in a kind of a predicament. We never want to, do anything against officers. We feel the pain sometimes. They are unreasonable. They are unreasonable in a lot of times. But at the same time, we don't have to get personal against officers. We appear for our clients, and in India, there are no such, at least the presidential law today on imposition of costs is not that evolved. If you see the US has a whole body of law, and especially where personal liberties are being violated. There are actions which are taken by judge-made law against officers, especially because they have the Fourth Amendment in the US Constitution, which is a constitutional protection against illegal searches. These actions in US are called Bivens actions, I think, based on a decision of the US Supreme Court, which is the genesis of this. In India, we don't have. In India, we have a judgment called Uranma, where the Supreme Court said that we don't have the same constitutional protections as the Fourth Amendment of the US. Now, I have written a series of articles on this. It's a very interesting subject. I have written a series of articles to say that after Puttaswamy's case, which has elevated the right of privacy under Article, it has elevated the right to a right to life under Article 21. After that, MP Sharma and Uranman, should it be reviewed by Indian courts? Because ultimately the searches happen, अब ED आ गई है, but otherwise tax law में सबसे ज़्यादा searches होते हैं. And oftentimes we feel that personal liberties of people are being violated mercilessly. आपका फोन ले लेंगे, आपका लैपटॉप ले लेंगे, आपको जाने नहीं देंगे, they'll confine you. अभी ये लॉ इवॉल्व नहीं हुआ है इंडिया में, like Bivens actions in the US. It needs to be evolved. As of now, I don't see, even as a professionals who appear in higher courts, that we should, given the present state of law, should be going against officers. But where there are gross violations, I think those will become test cases where the violation of right of privacy, court will take cognizance of and start granting compensation.
So if there are some other questions from the audience, please.